So lots to go on. Who's got questions, comments, hands up?
So hi there, super interesting. It sounds like you might be in agreement that you would keep contempt of court laws for things like jury issues, but not for revealing details of a case. I was going to touch on the whole, is it a problem that the Attorney General is a political appointee? There was a court case where there was a school bully kind of pushed around by some kids after he beat up a girl, broke her arm, and then someone reported that, and the Prime Minister said, oh no, it was a racist attack against his kid. That was Theresa May. She appointed the Attorney General, who then said Tommy Robinson is not allowed to say that this kid was a school bully. He was actually bullied himself as an immigrant. There's a strong case, and Tommy Robinson was contempt of court and put in prison for telling what seemed to be the truth in a documentary. That kind of contempt of court as a result of an injunction is probably quite different. I wonder what you thought about that. And if that is a problem because the Attorney General is politically appointed. Thank you.
Yeah, I was wondering if the panel could actually talk about and expand on the rise of injunctions through courts and how the courts had effectively invented super injunctions and things like this as mechanisms to suppress free speech. The other point I wanted to make to follow up with what we've just heard is that there is something about the way contempt of court is structured, the way courts behave, where they expect the public to act in a way which seems incredibly alien and undermines, I think, faith in the judiciary. So a good example of this is how you have to use the phrase like allegedly or suspected. Even you have scenarios where someone like the middle of Trafalgar Square shoots a bunch of people on camera and then goes, I did it, while in chains, and then the Prime Minister or the media has said, so the suspected or alleged suspect has done such a... And I think that this kind of so strict notion that unless it's been vindicated through a court is actually really hierarchical and vindictive towards the public, where it assumes that they can't use their basic common sense.
A mother's been in prison about, I think, is it 3 months ago? September, for contempt of court for sharing pictures of her daughter who doesn't have mental capacity. Now, she's done that completely out of desperation because where they put her, the care home was over-drugging her child. And they're trying to do the same with me because we're going through court of protection proceedings as well. And the, what's the word? Damn it. Coercion within organizations when a member of the public is up against an organization, we've got limited funds to fight those organizations. So when parents and families are being silenced and gagged by gag order, where are we meant to turn?
So I was the Mackenzie friend for Save Luba campaign. Luba is a mother currently in Bronzefield prison. My question around contempt of court is this. Last year I was taken to court by a legal firm in the name of a claimant, this is county, who didn't even exist. Doesn't exist. And I thought automatically that would be contempt of court, okay? When I spoke to the judge, she said, just shrugged her shoulders. Earlier this year, I was also again in court trying to take a legal firm for contempt of court on behalf of mortgage prisoners. So my question to the panel is this. As Farah quite rightly was speaking up, for those of us who are on the other side of the law, dealing with contempt of court, nothing exists. What, if anything, can the panel suggest how we can organise ourselves, how we can get funding and how we can get the support? Because it shouldn't be left to the, lives of everyday Brits like ourselves to be fighting on behalf of those who actually have got, in contrast, bigger pockets and deeper legal funds. And I'm really angry about it. So I'd welcome the panel's thoughts on that. Thank you.
Thanks very much. So we'll come back to the panel. If you want to, Helen, do you want to pick up on one or two things? And then we'll go this way. Then we'll come back out. And then we'll probably be done.
I'll just make a brief observation because I don't have the practitioner experience for those very specific UK questions, and Gavin and John probably do. Injunctions are a very different beast. They're nothing to do with contempt of court. They originated in the equitable jurisdiction in common law and the praetorian jurisdiction in Roman law. And the basic logic behind them is that they are remedies other than money. damages are money. Praetorian and equitable remedies are not money. That's the sort of key thing to remember. I have to say, once again, a big contrast here is the injunctions, that particularly the super injunctions, occasionally about footballers, but the really egregious one is the one about the Afghan leak, the Afghan Taliban leak. Oh yes, you were for us. Let's just tell the Taliban about you. Yay, winning. That is actually unconstitutional in Australia. You can't do that because it involves a court exercising legislative power. A court can tell, a government in Australia can pass legislation to shut people up. Australia has minimal human rights. It's the Benthamite jurisdiction. There are almost no human rights there. They're just simple acts of parliament. If people don't like them, like David Crisafulli just did in Queensland, they just repeal them. But the what that is, so the Ausgov could pass legislation to shut people up if it wanted to. It'd be a big, ugly public debate, but they could do it. But what certainly couldn't happen is a court doing it. So I have to say I do find the use of injunction, the promiscuous use of very wide-ranging injunctions in this country, alarming.
Yeah, but did you want to respond to any of the sort of practice?
I'm not to two cases. I'm not familiar with the facts, and I don't like to comment on cases where I don't know anything about them. I mean, on injunctions, yes, this is an area where actually we repeatedly lost cases at the European Court of Human Rights. A famous case involving Spycatcher, where the government tried to maintain injunctions, even when the book was published elsewhere, and so on, famously. Yeah.
And the reason the loss happened in the European Court of Human Rights is because H.F. Gov had already lost in Australia against, and the barrister who acted for Peter Wright was Malcolm Turnbull, who subsequently became Prime Minister of Australia. So,
I mean, I was just going to comment that, yes, I completely agree that it is about protecting jurors. So there's hardly any contempt cases succeed except in jury cases. So in relation to Lucy Letby, I mean, an appeal, if it was going on appeal, that wouldn't normally trigger contempt laws because the judges think that judges are not affected by media coverage. Only really juries are potentially vulnerable. And interesting, the research on this, because I did some research when I wrote an article about the American free-for-all that John introduced us to, shows that actually certain revelations are very damaging. And in particular, what juries, I think it's not so much, the research shows it's not so much sort of papers on stories that kind of impute guilt, but if they reveal specific facts, juries can't unremember those facts. And particularly that can include previous convictions and coerced confessions that are excluded in the trial. And the evidence shows that those are very damaging, and many jurors are unable to put those things out of their mind. So there is a good reason for protecting jury trials, as we said. Well, I mean, I think it's possible that the UK law could be narrowed and focused more specifically on particular risks, and perhaps, especially given the delays in the justice system, where from arrest to trial may be years now, there would be a case, I think, for shortening the active period as well.
Thank you. John, did you want to respond to the Attorney General point?
Yeah, I'm happy to do that because... and it's a sort of, I make a similar point with the super injunctions, really, which is that I don't think these principles are themselves objectionable. So, in fact, I think with the role of the Attorney General, I actually think that's quite desirable because so many of these issues involve the public interest. And I would rather have a political appointee having some supervisory role than I would have some state functionary like the DPP, Stephen Parkinson, making all of these decisions.
Is it put pressure on judges, though, the Attorney General? Was that not true?
I'm not sure how they put pressure on judges, but I mean they certainly have superintendents over the DPP. I think that's the wording. And you see it in the China case. It's in the papers today about how the Attorney General, because he's such a moron, he just shrugged his shoulders when he was told that the DPP was basically going to kill off this case. But you can't organise a system to cope with morons. You have to hope your Attorney General is going to understand what the public interest really means, and hence if you'd had a good Attorney General with the China thing, he would have said, no way, we must get the evidence so that we can see these alleged spies brought to trial. So I think there's always a risk in sort of seeing that there are individual problems and concluding from that there's something more fundamentally wrong. But I think that in principle the role of the Attorney General is an important one.
Right, so we'll have our final round of questions. There was two there.
Yeah, over the last few years, there's been a bit of a trend of new genetic evidence overturning old cases which were based on false eyewitness testimony. Is there any evidence that there's a higher rate of false conviction in America that you could relate to the free-for-all nature of it versus here, where we have a bit more of a protection for the juries?
Thanks very much. This is not my area, but I'm curious whether the panel thinks that legal advisors within newspapers are being too cautious, because it sounds from what I don't know this area, but it sounds from what you were saying that you being prevented from talking about or publishing information that you had in The Guardian may not have been in any way a contempt, or there are some other legal restrictions that may have prevented it. I'm just curious. I don't know.
Yeah, law's not my area either. Someone I know was in a domestic abuse relationship with a violent man, went to court, and the jury was never told that he actually had a string of historic abuse cases.
Yeah.
And I think that's wrong. And I think, when you have a history of domestic abuse, the recidivism rate's much higher. And I think that should be taken into account. Do you think that's fair?
I've got a question that I wanted to put to the panel. What do you think the Law Commission will do when they're sort of reviewing it? Helen, do you want to go first again?
I'll just talk about the prior convictions issue because I've dealt with that in practice myself. These are known when you either previous convictions or sets of behaviours. It need not necessarily be actual convictions, although that's the most common example of it. In other circumstances, it can be sets of behaviours. It's known as propensity evidence or tendency evidence, depending on the jurisdiction. It is, for the reasons that Gavin has already outlined, but I will reiterate them to you, famously prejudicial. And the rule in evidence is, you've got this two-part test here. Is it relevant? And is it admissible? Now, propensity and tendency evidence is almost always highly relevant. But the reason it's not admissible is because it is so, or often not admissible, is because it is so prejudicial. You then have to deal, and jurors can't park it, basically. They send the person to jail. And the thing is, you've got to remember that people aren't being put on trial for a bank of things. They are being put on trial for the things enumerated in the indictment. It's a trial on indictment on the charge sheet, depending on, because they call it a charge sheet up in Scotland. So it's for those specific libels, those specific charges. And this is a little bit like the genetics point that another person made, is that we now know there is very substantial criminological evidence, and this is globally, it's a human universal, that most violent crime is committed by a tiny member of the male population, and they're just notorious recidivists. I think that the figures that and these are relatively recent. It actually is European Commission figures. It's something like 80% of violent crime is 2% of the population, and that 2% is 95% male. It's just extraordinary. So these are things that modern science has researched and found out is true. But there are very good reasons why you want to try people for the thing for which they have been charged, not for all the other rotten things they might potentially have done in their life. And also the reality that there is an enormous amount of empirical research to show that jurors cannot just park it. If you find someone has been convicted for DV before and you tell the jury that, and he's up on a DV charge of whatever sort, that's how you finish up literally the jury retiring to consider its verdict and coming back literally 45 minutes later. And I have actually seen that happen. And the only reason it's 45 minutes is because they want time to have a cup of coffee in the jury room.
Gavin, did you want to pick up on anything?
Yeah, I mean, on in-house lawyers, I think they do tend to be defensive, including for newspapers, also for universities, as we know. On the Attorney General, I just wanted to add, I mean, I think there sometimes can be a problem because of the fact that he has to give permission for contempt proceedings to go ahead and is also a party politician. And there's been instances in which newspapers appear to publish extremely prejudicial stories. There was one about a notorious murder some time back. and the Attorney General refused to give consent for proceedings, and there was a suspicion that the government didn't want to incur the wrath of the press. So I think it does. I think the dual role of the AG can raise problems like that. And on the question about research, I mean, I'm not aware of research on whether more false, whether more convictions are overturned as having been found to be false. There is a study that showed that 72% of jurors exposed to stories containing inadmissible evidence, so evidence that was excluded in the trial but reported in the press in America, voted to convict, whereas less than 44% of them, not exposed to it, voted. So in other words, it did have a very substantial effect on jurors, as you've been saying.
Thank you, Gavin. Right, we had one question at the back. We've only got 5 minutes, so we'll take a question from Luke Gittos.
I'm interested in Tommy Robinson's case because he was subject to a very, very detailed judgment about why he had not told the truth about a young Afghan school kid. And he took it upon himself to ignore that decision and publish his libelous video anyway. Now, I come from this as a perspective that I don't agree with the libel laws that we have in this country. I think we should all be far more willing to debate these things in public. But I don't accept the idea that someone should simply take it upon themselves to ignore the findings of a court. Because if we're in that situation, then I think we do have to judge their actions morally as opposed to legally. So there can be instances where ignoring the court and going against the law is the morally right thing to do. And there will be other examples where it is the morally wrong thing to do. And when it comes to contempt, it plays a role in making sure that our courts have some sort of integrity. Because, if we are free to simply ignore their judgments, then what's the point of having a court at all? So, to what extent is this about the morality of ignoring the law? And are there cases where ignoring the law can be right and other cases where ignoring the law can be wrong? Just very, very briefly on jury trials. I do get very, very worried when I'm acting for defendants in criminal trials, particularly where there is adverse publicity. And I worry about a world where, for example, if someone is on trial for something they have said, a speech-related crime, for example, that any jury will be influenced by commentary, for example, calling the defendant a racist, saying they should go to prison. Once you open the floodgates by saying that you can write whatever you want about a criminal case, do you not create a scenario where criminal trials can effectively become a rerun of the political debate that's taking place in the media? And isn't that a very dangerous position for jury trials to be in?
Thank you, Luke. Right, so we're running very short on time. John, if you want to respond to that, and then we'll do closing remarks. So this is your closing remark, I'm afraid. 1 minute each, please.
Okay. I think the problem at the moment is that our law of contempt is just far too broad. So when I was researching for this talk, I looked to see if there was any guidance for all those people who might want to go on Twitter and don't quite know what they can say, or indeed for Max and other people who work in the press. And there is, fun enough, some guidance. It comes from the Attorney General, so you know immediately it's probably going to be useless. But it's actually the Attorney General's Contempt of Court guidance for use of social media. So you think, right, this is just what I'm interested in. So what does it say? It says a post could be contempt if it, quote, comments on facts or evidence that will be heard during the trial. Now, since no one knows what facts or evidence are going to be heard in the trial, what it basically means is you can't post anything. Or if you do, you run very serious risks of facing up to 2 years in prison. So the law at the moment is a joke, and it means people can't comment. Even respectable people can't comment, and that's why journalists are so risk averse for understandable reasons. So I actually think Gavin made a very good point about how there might be some way which moves more in the American direction of saying there are particular factual matters that you cannot ever comment on because we know they're likely to be so prejudicial, such as someone's previous convictions. But other than that, I would be in favour of allowing much more free speech on this issue.
Thank you, John. Helen, 1 minute, please.
Just a brief comment on the disobeying the law. There are very, very serious problems with not abiding by court court rulings and court orders. We're seeing it now with the Supreme Court. It is something that does this little retired lawyer's head in. It really does. I am alarmed by it enormously. So there's very casual attitude to legal enforcement. Certainly not something you see in Australia, I have to say. The police there, the law enforcement. So there's that. The other thing on and I'm going to have to use the phrase is the lex injusta non est lex point, which is an unjust law is not law, which is the basic principle of the legal system, or theoretical legal theory system known as natural law. My view has always been, if you're going to set yourself up as some sort of moral arbiter and break the law, then you have to do what the Reverend Dr. Martin Luther King did and be willing to go to jail for it, which is why I have the highest of respect for Martin Luther King and his legacy, because he was willing to go to jail. Whereas I think that Snowden fellow who ran away to Russia after breaking the law is a complete twat.
Gavin.
So that's
Sorry.
basically.
1 minute, please, Gavin.
I find, I don't think showing that the AG produced extremely inaccurate and unhelpful guidance shows that law is the problem. That guidance is the problem. I mean, yeah, that is completely. He should have just said what the test is: the substantial risk of serious prejudice. Don't do that.
Thank you very much, Gavin. And please, join me in thanking.